I'd like to save a few minutes for rebuttal. I'm not sure how much time we have.
You have up to 5 minutes.
I'm sorry?
You have up to 5 minutes.
For rebuttal. Okay, super.
Yeah.
Thank you. Your Honors, we have two questions to answer today. The first is whether the plaintiffs have pled a reasonable basis to add a claim for punitive damages. The second question is whether, if so, those damages can be imputed to Publix, whether Publix can be liable for them. The answer to both questions is no, and I will address each one in turn. Your Honors, punitive damages are an extraordinary remedy. They're reserved for conduct that is so reckless and wanting in care that it constitutes a conscious disregard for the life and safety of others. This court has likened it to conduct that can be prosecuted for criminal manslaughter. We don't have that here. What we have here is an activity in a store that had been performed hundreds of times over a 2-year period. Heavy items had been put on and off the shelf many times. Mr. Tatarabak, the store manager, says, I've unloaded and loaded that shelf. It's had heavy things. It's had heavy bottles of water, bottles of wine. We've never had an incident. There's never been a problem. There's never been a concern. There's never been a scare. Never. It can't be said that a person in like circumstances would say that danger to life or injury was imminent. The 5th District said in Hospital Services versus Dean, it's not enough to say that something may happen. It has to have a high probability that it will happen. This court also in Fleetwood said that it explained, Judge Altenburg explained that any moderately dangerous activity in the workplace that is
Mr. Wolf, let me interrupt you about Fleetwood because you rely on it fairly extensively, and in your brief you say it was reversed on other grounds. And my recollection is that Fleetwood was actually quashed on the basis that the DCA lacked jurisdiction to review the trial court's order. And if that's the case, isn't Fleetwood a nullity? Could it even be something we could rely on at all?
Well, I don't think it was reversed on the, Fleetwood has the same standard for gross negligence that many, many other cases do. I think we cited it in this case because it's your court and you said this. It wasn't quashed on those grounds. It was a workers' compensation case, but Judge Altenburg took that part of it and explained what gross negligence is. And if you have an activity that's been done hundreds of times, you can't say that the danger to life and liberty is imminent. This case is not AMC Motors. This isn't Bridgestone Tires. Bridgestone Tires knew that their tires were separating. They knew their tread was separating. They knew that people had accidents. They had been sued before, but they didn't recall the tires because they didn't want to spend money. AMC Trucks, the same thing. They did crash tests. They knew that their fuel tanks would blow up if they had an accident. They would catch on fire and people could die. But did they move the fuel tanks? Did they recall those trucks? No. And people got injured. That's not this case. We've never had an accident. These shovels have been loaded and unloaded every single week. They get changed out every single week. And product is moved like the plaintiff in this case. This wasn't the weekly change out. He came in, he looked at the aisle and he said, ooh, I don't have any product on the aisle. I need to go get it from the end and I need to put it over here. This wasn't even the weekly change out. Product is moved every single day and there's never been an incident. So in this case, I don't think we could say that any danger was imminent. But even if you did think that, if you did think that this was punishable with punitive damages, you have to be able to hold Publix as the corporation liable for those damages. And you can't do that here. So there's two ways, right, to get punitive damages out of the corporation. You either have to travel under direct liability or vicarious liability. Little confusing which one the plaintiff is traveling under. I believe it's direct liability. They say different things in their brief. Page 5, Publix had knowledge and Publix warned. So, but of course we know the only person he warned was Mr. Tatarabak, the store manager. They
I
say.
think he was speaking as the corporate representative during his deposition, wasn't he?
Well, in his deposition, what he said, okay, good point, Judge Rothstein Newcomb. A corporate representative is not an officer of a corporation. It is not what this court has described in Florida Power and Light versus Dominguez as a managing agent of a corporation. You can be a corporate representative for giving a deposition for a particular thing, and if you believe the emails in this case, the particular thing was that particular end cap in that particular store, right? But I can be a corporate representative for mediation for purposes of having the authority to settle. But does that make me an officer? Does that make me a manager or a managing agent with authority to have ultimate policy-making decisions for the entire corporation? No. Mr. Tatarabak is a store manager for one store. Publix has over 1,400 stores. He is at best a mid-level manager, and Judge Kuzam explained all of this in Florida Power and Light versus Dominguez. She said a corporation cannot act alone. There must be willful and malicious conduct on the part of a managing agent. Then she says a managing agent is not a mid-level employee. It's not one of several bank VIPs. It's not a job foreman. It's not a single hotel manager of a bunch of hotel managers. It has to be someone who's the president, a primary owner whose acts are those of the corporation. Also, in Napleton Auto Parts versus Augusta, the managing agent is a policymaker. It's corporate management. It has to be a person with ultimate decision-making authority for the corporation. One who manages a single unit of units is not a managing agent. Mr. Tatarabak manages one store out of 1,400. And even in the amended complaint, what they've said is Publix knew, Publix warned, Publix didn't put a bolt in, Publix did nothing, Publix didn't put a sign. But all of those things are Mr. Tatarabak, right? So what they're doing is they're reciting supposed negligent actions of Mr. Tatarabak, and then they're putting Publix's name on it to characterize Publix as being the perpetrator. We don't have any negligent acts on the part of Publix, the corporation, unless you decide that Mr. Tatarabak is a managing agent of the corporation, which he clearly is not under this court's authority and others. For those reasons, any malicious punishable action on the part of Mr. Tatarabak cannot be imputed to Publix. Publix cannot be liable for it. And I will save the rest of my time for rebuttal in case you have any questions.
5 minutes.
Thank you.
Thank you, Counselor. Good morning, Your Honors. May it please the Court, my name is Bobby Jones. I'm here on behalf of the appellee, Christopher Levi. And I'm going to start out my presentation by saying that I see this here case as a case of Mr. Tatarabak having knowledge, participation, and the power to act. And I'm going to go through each one of those. He had the knowledge. He testified that he had warned all the vendors that if you remove this product from the bottom shelf, it could collapse on top of you. And as you know, if you've actually looked at the...
He gave that warning, but he had no experience with that actually occurring, is that right?
Correct. Yes, he had never had that actually occurred in the past, but he certainly was aware of the danger. Otherwise, he wouldn't have given that warning saying you shouldn't take it from the bottom because it could collapse on you. And
Let's be really careful with the language used, because my recollection is, did he say you shouldn't do it, or did he clarify? And unfortunately, I don't have, say that.
I can cite it directly for you. What he said was, I didn't say not to do it, I said I wouldn't recommend it. That's specifically what he said in the deposition transcript.
And that's because it's sort of basic physics, right? If you make something heavier on top than on the bottom, it makes it unstable, even if it's not inherently unstable.
That's exactly right, and that's why he knew that he could have secured it and made it safe for the vendors, but he didn't do it.
So you're saying because there is a way to make something safer, if you fail to do it, then the complainant is entitled to punitive damages.
In the case where you know that you're warning people that it could potentially fall over on top of you and there's a simple fix to do it and you refuse to take action for more than 2 years for business invitees and people coming in, we owe a duty of care to do that, and you know there's potential for danger and you take no action. See, this is different than those other cases that they cite to. None of the defendants in that case admitted that they knew there was a danger. None of the defendants in that case admitted that there was a simple fix to do it. What distinguishes this case from the other cases where you have all these horrible things that happen to people, but the defendants didn't really know or didn't admit that that there was potential for that to happen, and didn't admit that there was an easy, simple fix to do it. And that's the problem we have here. And so that's why I say he had the knowledge that there was the potential for something to happen. He actively participated in it, and he had the power to rectify it. And so whenever someone has that knowledge as a business invitee, knows that there's a simple fix to do it, and doesn't do it, to me and to our side, we think that fits the definition of gross negligence. Number two,
It sounds to me more like negligence. Had there been previous incidents that they had ignored or lied about or swept under the rug, then you might have something. But he's just giving it sort of a general warning, as if you were walking through Publix and said, look, this aisle is kind of narrow, so watch yourself. I mean, he's not basing his warning on anything that actually had occurred. It was more of almost like a common sense comment, seems to me.
well, we see it a little bit different in that, Your Honor, that whenever you know of a specific danger, it's different than some general danger, walking down, watch out, don't trip and fall over something, or watch out for rocks, things of that nature. That's what I would consider simple negligence. If you know of a specific danger, like for instance, in the Ellis case and the other cases about tire tread separation, they never admitted they knew there was a danger in that case, but the evidence showed that they should have known that there was dangers in those cases. And the courts have not been reluctant at all to say, if you know there's a specific danger and you can take actions to stop it and you don't do it, then that is gross negligence.
So Mr. Taterovich, I don't think testified that there was a specific danger. He said, there's nothing wrong with those shelves. What he said was, if you unload them in such a way so that they're heavier on top than they are on the bottom, they could fall over, which again is just sort of common sense, basic physics. But as far as the danger being posed by the shelves, there was no defect in the shelves. It was the misuse of the shelves that resulted in the danger.
Okay, and I understand what you're saying, Your Honor, but it's no different than knowing there's a pothole in a road and that people could avoid it. But you know it's there, and you do nothing, and you intentionally do nothing to take care of that pothole. Sooner or later, somebody's going to run into that pothole and hurt themselves seriously. So it's the knowledge, I think, is the specific knowledge of it being able to crash over and seriously hurt somebody, I think is, and the ability to take care of that and the refusal to do that, I think is where it gets to the level of disregard, if for the rights and the potential safety of other people coming into your place of business, and you did nothing to take care of it. And as far as Mr. Taterovich not being the corporate agent, Publix, he was noticed as the corporate representative, and specifically in the areas of inquiry, Your Honor. We talked about what were the policies and procedures of keeping the shelving safe, so he was produced as the person with the most knowledge about that. And so when we asked him specifically, has Publix given you any direction on how to maintain this shelving as far as whether to secure it, make sure that it's safe? Nothing came from Publix to him. So essentially, they have abdicated their policy-making decision to the local general store manager. And so he is speaking for Publix. Whenever he makes those decisions on site not to fix something that's dangerous, then he is speaking for Publix. In the Florida Power and Light case, this court came out, Judge Nellie Kuzan wrote that opinion. In that case, it was Mr. Grubbs, and it was a sad case, but the sober analysis of it is a boy climbed up some vegetation and went over it, electrocuted him, and killed him on the spot. Florida Power and Light had a specific policy that says keep vegetation away from power lines because it's inherently dangerous, And in fact, somebody might even climb up and get electrocuted, specifically even said that. The corporate representative in that case was a corporate representative who had no knowledge of the facts, was in charge of that area, but unbelievably didn't know that someone got electrocuted on his watch. Didn't have any power to set any policy whatsoever. Why? Because they had taken the time to put the policies and procedures in place. And so that makes sense in that case, because if a company comes in, puts out the policies and procedures, thinks it through, puts out the policies and procedures, and you have an employee that violates it without their knowledge. Now, if they start to know that that's happening, then you get into the condoning situation. But if you get someone who violates it without their knowledge, then I get why the corporation is not going to be held liable for punitive damages in that situation. But that's not what we had here. What they did is abdicated and left the complete decision-making up to him, so he set the policy for Publix, and therefore he's speaking on behalf of Publix. There's no way you're going to, Mr. I can't remember his first name, but the CEO of Publix, his last name is Jones, no relation. There's no way you're going to get him involved in such a small item like this here. That's why I think Publix makes the decision. Let's leave the safety of these particular items up to the local store managers, and therefore they are the corporate representative and the managing agent for Publix in that situation. And that's all I have, Your Honors, unless you have any more questions.
I have a question.
Sure.
If we were to affirm, can you sort of put into one sentence what principle of law we would be putting forward? I mean, is it something like, if there is a way to make your store safer and you don't do it, you are liable for punitive damages? Can you just sort of crystallize it, please?
Yeah, if a company does not take the time to analyze the safety of a particular item in a particular branch of that corporation and leave it up to the store manager to set that policy, then that person is speaking on behalf of the corporation and sets the policy for the corporation as it relates to that particular issue.
Okay.
Okay. Thank you. Thank you for your time. Thank you.
All right, 5 minutes.
Thank you. Very briefly, Judge Bott, to your question, yes, it was reasonable. This was a common sense comment. I wouldn't do it that way if I were you. It's no different from saying I wouldn't lift with my back, I'd lift with my legs. I wouldn't stand up. I would let your kids stand up in the car. I probably wouldn't do that. There's not a specific danger here. There was no specific danger that was found. The shelves were just fine. Judge Rusty, I think this is your question. Council has likened it to a pothole, which a pothole is not a shelf that has no defects, right? A pothole is a pothole that it is a defect that needs to be fixed, that the city lets you get online and tell them that the pothole needs to be fixed. The argument, I think, is because Publix doesn't have a policy for putting bolts in shelves or maintaining shelves or something like that. So they leave it up to the store manager. So then what they say on page 27 of their brief is that Mr. Tatarovic therefore is Publix. He is a policymaker for the corporation because he's the board, the president, and the managing agent for Publix when it comes to decisions in the store he managed. But that's not the standard, right? It has to be someone who makes ultimate policy decisions for the entire company. And that's not Mr. Tatarovic. So for those reasons, because we don't have punitive damages here, we don't have any activity that could rise to gross negligence. It's not even pleaded that way in the complaint. And furthermore, because Publix cannot be liable for punitive damages if there were any, we ask that this court quash the order. And if you have no more questions.
Thank you very much.
Thank you very much.
Now we're back on track. We're going to go with that Panera Bread.